Hey folks, Dave Ceruolo here, real estate, probate, and elder law attorney. In this video, we're going to talk about the three major documents that you're going to need in any simple estate plan. Don't forget to hit the subscribe button as you're watching. Stay tuned. So in a simple estate plan, a person will create a will, a healthcare proxy, and a power of attorney. Now, flashing forward to the durable power of attorney, this is a formal document, folks. A person will put this in place where they'll create this document to appoint a loved one or a friend to take care of that maker, that person's stuff, their real estate, their investments, and their money. And so the reason why this is done is it's part of a plan once again, and the maker is going to appoint this person of trust called a fiduciary to take care of their stuff if they should not be competent to do so. The family or the loved one won't have to go to the court to get a judge's order in order to take care of the maker's stuff. And that would be called a conservatorship, right? That's not necessary if there's a durable power of attorney in place. Dave Ceruolo, CeruoloLaw.com. So in a simple estate plan, usually a person will make a healthcare proxy, a power of attorney, and a will. Now, a healthcare proxy is a simple agency, as we say, and the maker will appoint someone that they trust, preferably a loved one, to make decisions on behalf of them should they become sick and not able to make those decisions. So the agent will tell the doctors what to do if the maker gets sick. Now, the healthcare proxy only is around for as long as the maker is alive, and it only comes into effect when the maker is unable to make their own decisions with respect to medical treatments. Now, types of things that the healthcare proxy will talk about: medications that can be administered, whether they're antipsychotic or not. They'll talk about life support, should that become necessary, and whether they want the agent to keep them on life support. Now, once again, once the maker passes away, the healthcare proxy passes away with them. Dave Ceruolo, CeruoloLaw.com. So what's a will? Well, folks, a will is a written instrument or document that's created by a person in order to dispose of their property or divide their property at the time of death. Now, the will designate a person to take care of the estate at the person's passing. It's called now the personal representative. Now, to make a will, a person has to be 18 years of age or older. The person has to actually sign the document. It has to be in writing. The person has to be competent, has to be able to have the ability to understand what they're signing. And the document needs to be witnessed by two disinterested persons, people who aren't named in the will or part of the estate. Now, if a person dies without a will in Massachusetts, it doesn't automatically go to the state, folks. The laws of intestacy take over at that point, and there's a way that property is divided if a person doesn't have a will. Dave Ceruolo, CeruoloLaw.com.